Good evening. Thank you for joining us. I'm Trevor Morrison. I'm the Dean of the Law School, and I want to thank all of you for being here with us tonight. Each year, the NYU Annual Survey of American Law dedicates its forthcoming issue to an individual who has made a significant contribution to the law and society. We've had the privilege of honoring distinguished justices, including many members of the US Supreme Court, lower federal courts, state Supreme Courts, many distinguished academics as well from our faculty and the faculties of other leading schools across the country. And I am delighted that our students have chosen to dedicate the 77th volume of the annual survey to Barbara Underwood, Solicitor General of New York. General Underwood will be formally introduced in just a moment, but let me say how thrilled we all are here at NYU to celebrate her truly trailblazing and inspiring career. Barbara, in fact, spent the early part of her career on the NYU Law faculty, and so we as a school are especially pleased to welcome her back. And I had the great honor of working with her in the US Solicitor General's office for another of our speakers this evening, and so it's a great personal pleasure for me as well to welcome her here. With that, I will turn the program over for now to this year's editor-in-chief of the annual survey, Sander Saba.
Hi, everyone. Thank you all for coming. My name is Sander Saba, and on behalf of my journal, NYU Annual Survey of American Law, I want to welcome you all to our annual dedication ceremony where we celebrate Solicitor General Barbara Underwood. Since our journal was founded, Annual Survey has strived to be the practitioner's journal, which I'm sure to some of you sounds like a bit of an oxymoron. Annual Survey was originally compiled by NYU Law faculty members to serve as a practical, comprehensive guide to developments in American law. Since becoming a quarterly student-edited publication, we continue to honor our practitioners through the practical materials we publish, the relevant symposia we host, and of course, our annual dedication of the upcoming volume to a distinguished member of the legal community. Now, I'm sure we can all agree Solicitor General Underwood is an obvious choice. My journal's board certainly thought so. She was the first woman to serve as Solicitor General of New York before becoming the first woman to serve as Attorney General at a time when the people of the state needed her most. In her short time as Attorney General, General Underwood stood up for New Yorkers hundreds of times, fighting against harmful policies of the Trump administration, against companies taking advantage of their customers, against those who destroy the environment and lie about it. And she won a lot. And that's just listing some of her recent accomplishments. Throughout her entire career, Solicitor General Underwood has served as a guardian of equal justice for all people. She successfully fought against racially discriminatory jury selection, defended the constitutionality of reasonable buffer zones around women's health clinics, and last year persuaded the US Supreme Court to vacate the decision to add a question about citizenship to the 2020 census. She has also served for years as a mentor, earning the Professionalism Award from the American Inns of Court in 2012, honoring her many, many years of mentorship. And as Dean Morrison mentioned earlier, and I am proud to repeat, she did used to teach at NYU Law. I truly could speak for hours about her accomplishments and how well respected she is by her colleagues, but then we would have brought all these folks here for no reason. But before I hand it over to our wonderful dedicators for their remarks, I want to thank you all for coming and give an especially big thank you to Solicitor General Barbara Underwood for the incredible work that you do every day. We are honored to have you here.
Okay, so the run of show here is that I'm going to give a very quick introduction to each of our dedicators, and it's my pleasure to start by introducing Zachary Carter. Zach has led a terrific career in public service, most recently as Corporation Counsel of New York City under Mayor de Blasio. His earlier posts include serving as a U.S. Attorney for the Eastern District of New York. He's also a graduate of the law school, of whom we are very proud, and we're glad to welcome him back this evening. Zach Carter.
Good evening. I have been called upon to deliver remarks in tribute to Barbara Underwood on several occasions, and I have never run out of good things to say. Now, I could simply repeat what I have observed about Barbara on those prior occasions, and some of those things do bear repeating. But I can honestly say that each time I have had the opportunity to reflect on the 40 years that Barbara has been my friend and professional colleague, I always remember some additional attribute of skill, character, leadership, or professionalism that I have not focused on before. I think it is fair to say that in the earlier part of her career, Barbara was something of a commuter, physically commuting between New Haven and New York City, but also metaphorically commuting between academia and public law practice. To me, this reflected her belief that scholarship informs the best law practice and that law practice informs the best scholarship. There came a point in time, however, when Barbara made the choice to devote her career to full-time public service. That choice was consonant with another of her core beliefs, that the ultimate purpose of law is to serve the needs of ordinary people, to deliver equal justice to all before our courts, and equal protection to all from abuses of government authority. Among the most prominent beneficiaries of Barbara's decisions over the years to accept a host of leadership positions in public law offices are the hundreds of appellate lawyers who have honed their skills under her guidance. Barbara's approach to leading young lawyers is akin to that of a general willing to get into a foxhole together with the lowliest private. When she decrees that every appellate lawyer will be mooted in preparation for each and every oral argument, no matter how senior the lawyer, she herself submits to mooting by her attorneys before every one of her appellate arguments. When Barbara meets with her attorneys to discuss the difficult legal challenges presented by one or another pending case, Barbara, almost always the smartest lawyer in the room, often prefaces a question with, "I know this may seem like a stupid question, but..." Now, it never really is a stupid question, but this humble gesture creates a safe space for each of the attorneys in her charge to ask the questions they may have been too embarrassed to raise, and quite probably was on everybody's minds anyway. Barbara, the former tenured professor, never treats appellate practice as an academic exercise. She understands the stakes for real people and for our shared institutions. She teaches her lawyers to think strategically and to accept the challenge of persuading appellate judges to accept the legal positions being advocated. The written submissions she authors and edits are not law review articles masquerading as appellate briefs. She understands that effective appellate advocacy appeals not just to reason, but also to the instincts, intuition, and common sense of all too human judges. Lastly, apart from her extraordinary work in appellate practice, Barbara has demonstrated a capacity to lead public law offices with great distinction, even when these responsibilities have been thrust upon her on short notice and under peculiar circumstances. After serving as my chief assistant U.S. attorney when I was U.S. attorney for the Eastern District of New York, Barbara was appointed Principal Deputy Solicitor General of the United States and thereafter served as Acting Solicitor General of the United States. Most recently, under circumstances with which you are doubtlessly familiar, Barbara, who had served for several years as the Solicitor General for the state of New York, was called upon to serve out the unexpired term of the then Attorney General of the state. The distinction with which she executed her responsibilities in that unprecedented situation cannot be overstated. She took command of that office in a manner that restored morale of a shaken workforce, and she set about aggressively pursuing the people's business. She defended against assaults on the state's sovereignty from a hostile federal administration in Washington, and she unhesitatingly pursued investigations implicating the politically powerful. She was no caretaker. She was the Attorney General of the state of New York, and she made us proud. All of us are grateful for Barbara's distinguished public service, and we know she's not finished yet.
Okay, thank you, Zach. Unfortunately, former Congresswoman Elizabeth Holtzman is unable to join us this evening. She is one of the other dedicators. She sends her regards and regrets, and so Sandra will read her remarks now.
Hi again. So I want you to just imagine that I'm the incredibly accomplished former Congressperson Elizabeth Holtzman. I think we can do this together if we really try. But in all seriousness, her remarks are very important, and I'm honored to deliver them on her behalf. I am very honored to participate in this tribute to Barbara Underwood, whose contribution to the advancement of the rule of law and to justice has been enormous, and to join such distinguished persons in doing so. I will speak from my perspective as District Attorney of Kings County, aka Brooklyn, New York, from 1982 through 1989. Newly elected and never having worked as a prosecutor, I was in sore need of a strong, able, and wise leadership team consisting of smart, experienced, non-political prosecutors. The chairs of my transition committee recommended Barbara. Although I had never met her or heard of her, Barbara's credentials as a Radcliffe graduate and Yale law professor spoke volumes about her intellect. Still, I wanted to get a better sense of her values. At the interview, we hit it off immediately. I was humbled that she was considering being part of my administration. She wanted to head a bureau, not merely be an advisor, and so I agreed to appoint her as chief of the Appeals Bureau and legal counsel to the DA. She joined an outstanding group of prosecutors, including William Donino, who had served in the governor's office and wrote commentary for McKinney's volumes on the New York State Criminal Code, and Zachary Carter, who later became U.S. Attorney for the Eastern District of New York and Corporation Counsel of New York City. My first major case and first major interaction with Barbara had to do with the matter of racially based peremptory challenges. It was a subject that would occupy us for years. The case involved Reginald Thompson, who had been convicted under the prior DA and was appealing on the ground that the DA's office used peremptory challenges to remove all blacks from the jury, thereby violating his civil rights. The Intermediate Appellate Court, the Appellate Division, had just agreed with the defendant and overturned his conviction. Was I going to challenge that decision, the office wanted to know? For me, the answer was easy. In my first summer at law school, I worked as an intern for an African-American civil rights attorney in Albany, Georgia, and had seen the system of Jim Crow up close. There was no way I would support racial use of peremptory challenges, but I wanted to know how my leadership team felt about such a fundamental issue. Without disclosing my feelings, I asked their opinion. The next day, they all said, Barbara included, that the office should agree with the appellate division and that a prosecutor may not legally use racially based peremptory challenges. My heart sang. It was important to know that we shared this basic belief that the criminal justice system couldn't engage in deliberate racial injustice. Winning wasn't everything. But this case and the problem it presented triggered what became for both Barbara and me a long journey to rid our court system of racist jury selection. With Barbara's help, I issued a memo to the office barring the use of racially based peremptory challenges by any assistant district attorney in the office and requiring that the reasons for any peremptory challenges be recorded. This was a vital point because in our effort to fight the legal structure permitting racial peremptory challenges, my office would be able to show that stopping the racial use of peremptory challenges did not create any serious administrative burdens. Barbara also agreed that we needed to extend the bar on the use of racial peremptory challenges to defendants, not just prosecutors. We had seen the problem in a Brooklyn case involving some white thugs who surrounded 3 black transit workers after they had left their midnight shift with the transit authority and stopped to get a bite at a bagel shop located in a white neighborhood. 2 workers managed to escape, but the 3rd was beaten to death. At the trial, despite our protest, defense counsel used 15 peremptory challenges to remove every black person from the jury. Although convicted, the defendant was acquitted of murder. How to cover defense counsel was the critical question. Defense counsel, after all, were not normally viewed as state actors, thereby implicating the 14th Amendment and its equal protection requirement. Barbara and I discussed the matter, trying to figure out the answer. At some point, we both recognized another approach. The victim of the racial use of peremptory challenges was not just the prosecutor or the defendant, but the juror who was removed from the jury panel on account of race. This insight allowed Barbara to attack racial use of peremptory challenges from the broadest vantage point, including not just defendants' rights and the public's right to fair trials, but the potential jurors as well. By coincidence, I received an anonymous letter from a prospective juror in Brooklyn. He was sad and angry that he had not been selected and said it was for racial reasons. Although the letter was ungrammatical and filled with misspellings, it was a powerful example of the injury to the excluded juror. It made our point vividly. The prospective juror had urged me to refer his letter to the right place if I couldn't solve the problem myself, and Barbara agreed that we should append the letter to a Supreme Court brief, which we ultimately did. Barbara finally found a case we could use as a vehicle to attack racial peremptory challenges, People versus McCrae. The defense argued that my predecessor had used racial peremptories in securing McCrae's conviction. We could agree with the defendant that racial peremptories were unconstitutional, but would disagree that in McCrae, the prosecutor's peremptories were racially motivated. We could also argue that racial peremptories were unconstitutional if used by a defendant. Surprisingly, we lost the constitutionality argument in New York's highest court, which decided that racial use of peremptories did not violate any rights. So much for New York as a truly progressive state. Still, with Barbara's unerring guidance, we plowed ahead. Our office petitioned the US Supreme Court for certiorari. It's the first time I've ever said that right. Although the Supreme Court denied our petition, we were jubilant. 2 justices wanted to abolish peremptories entirely, and 3 others wanted lower courts to reconsider a prior Supreme Court case, Swain versus Alabama, which held that racial peremptories could be challenged only on a showing that they were being used systematically in many cases over time, an impossible burden. Barbara's strategy was working. Basically, 5 justices, enough for a victory, were troubled by racial peremptory challenges, and we were on our way. At Barbara's urging, we went next to the Federal District Court in Brooklyn, where Judge Nickerson, finding authority in the Supreme Court's call for a reconsideration of Swain, essentially overruled Swain, deciding that racial peremptories were unconstitutional even if used in a single case. The Second Circuit affirmed. We were getting very close. We petitioned for certiorari again, but the Supreme Court again did not take our case, choosing instead a case from Kentucky, Batson v. Kentucky. It was not a surprise, Barbara explained. There was no dispute between my office and the defendant on the central constitutional issue, namely whether prosecutors could constitutionally use peremptory challenges to remove blacks from the jury. Instead, it was only an issue of fact, whether the peremptories had been actually racially motivated and whether defense counsel could be covered that separated the two parties. In Batson, the court had a prosecutor claiming the right to use racial peremptories. The issues were fully joined in Batson. And the rest is history. Although the court did not take our case to rule against the racial peremptory challenges, there's no question that our litigation helped pave the way for the momentous Batson decision. Just check Justice Stevens' footnote on the subject. We filed an amicus brief which upon rereading 35 years later is still eloquent and strong, and Barbara helped to prepare Batson's counsel. Barbara had pioneered a landmark decision in this country's fight against racial injustice, a remarkable accomplishment. It is worth noting that not a single other prosecutor joined in our amicus brief. Barbara played a similar role in another groundbreaking case, the People versus Liberta. This case involved the question of whether New York State could constitutionally fail to protect married women from rape by their husbands. My office's involvement in the case began when Barbara, as was her wont, walked into my office with an idea. She suggested that we file an amicus brief in a case that was being argued in a New York's Court of Appeals. The case involved the prosecution of a husband who had forced his wife, they were living apart, to engage in sex with him in front of their child. The defendant was indicted for rape and sodomy, but he attacked his conviction because both statutes had a marital exemption. The prosecutor did not challenge the constitutionality of the exemption, but contended that the exemption didn't apply. Naturally, the defendant didn't challenge the exemption either. I strongly agreed with Barbara that the marital rape exemption was legally and morally obnoxious and authorizing the filing of an amicus brief. Underpinning the exemption was a deep-seated view that a woman was the property of her husband and lost autonomy over her body at the altar. At that time, many states did not criminalize marital rape. Even though it is almost unheard of for a court to adopt a position not advanced by either party to a case, that is what happened in Liberta. The Court of Appeals declared the statute's exemption unconstitutional, and in ringing words that the exemption for married women denied them equal protection, in ringing words held that the exemption for married women denied them equal protection of the law. It stated, a marriage license should not be viewed as a license for a husband to forcibly rape his wife with impunity. A married woman has the same right to control her body as does an unmarried woman. This was a great victory, inspired by Barbara. I strongly believe that the Liberta decision influenced other states to protect married women from non-consensual sex with their husbands. In fact, today, no state has a complete marital rape exemption, although some protections for married women are not as robust as they need to be. Discussing Barbara Underwood's accomplishments reminds me of the prayer and song Dayenu, which is recited at Passover. Loosely translated, Dayenu means it would have been enough. If Barbara had achieved only the Batson victory, that would have been enough. If she had also achieved the Liberta victory, that would have been enough. But Barbara did much more. For example, she felt strongly about professionalizing the office and made great headway in that respect. One of her innovations was to require moot courts before appeals were argued, ensuring that young assistant DAs would be properly prepared for their oral arguments. No more shooting from the hip. She helped on recruitment, bringing into the office extraordinary young lawyers from around the country. She also gave invaluable advice in the difficult cases we encountered. For example, towards the end of my tenure, we were faced with a charging decision in a case involving a young black man who was looking for a used car, and in response, a newspaper advertisement went to Bensonhurst, a predominantly white neighborhood in Brooklyn. The young man, Yusuf Hawkins, was surrounded by a group of thugs. One had a pistol and shot him. Since the DA's office was responsible for advising the grand jury on charges that legally could be brought, we had to decide whether to present the grand jury with a charge of murder in addition to other charges. Was a murder charge warranted by the facts and the law? Strategically, was it appropriate? I brought all the interested parties into my office to discuss the issue. There were heated debates, but Barbara's voice, calm and wise, guided our deliberations. Barbara was respected and admired by the assistants in the Appeals Bureau, and indeed by everyone who worked for or with her. Despite her intellectual brilliance and her enormous grasp of the law, she was always approachable and willing to share advice. The people of Brooklyn, New York State, and the nation have benefited greatly from her extraordinary service. Thank you.
think the Congresswoman gets points for most creative use of Dayenu I've ever heard in a law school address. I now have the great pleasure to introduce Pam Karlan. Pam is the Kenneth and Harl Montgomery Professor of Public Interest Law at Stanford, where she is also founder and co-director of the Supreme Court Litigation Clinic, one of the most thoughtful and influential scholars of constitutional law in the country, especially as it relates to voting rights, civil rights, and anti-discrimination law, a former clerk to Justice Blackmun, and former Deputy Assistant Attorney General in the Civil Rights Division of the Justice Department, and former student of General Underwood, then Professor Underwood. Welcome, Pam Karlan.
So as Trevor said, I think I'm here to speak because I was a student of Barbara's, and it's a little bit like a lot of people didn't know she had a first act in life. It's sort of like people say, Governor Schwarzenegger, what did he do before? And he was a movie star. Or Justice White, what did he do? He was a football player. Or Justice Alan Page, who was also a great football player. So my opportunity is to speak, I think, on behalf of the former students. So in 1947, the St. Louis Cardinals held an event to honor the great Yankee catcher and American philosopher Yogi Berra. After hearing all of the accolades, Yogi stepped to the microphone and he exclaimed, "Thank you for making this day necessary." And I feel the same way about Barbara, so thank you, Barbara, for making this day necessary. As someone who's benefited tremendously throughout my career from Barbara's sage advice, I think that Barbara herself has lived the best piece of professional advice I know, coincidentally, not actually, from Yogi Berra, which is when you come to a fork in the road, take it. Now, contrary to textualists like Justice Scalia, what Yogi is not saying, when you see a piece of spare cutlery lying in the street, you should pick it up. Rather, what he is saying is that we should resist a false choice because truly great lawyers take both paths from the fork. In the spring of 1981, I was taking my first course with Barbara, a course on sex discrimination. And that spring, she published a short piece in the Yale Law Journal entitled Against Dichotomy. In that essay, Barbara resisted coming down decisively on one side or the other of what she described as the tension in law schools between our ties to the legal profession and our scholarly aspirations. On the one hand, we train our students to become lawyers, to live active lives in the law, much of the time advocating on behalf of particular clients or interests, or counseling clients on how to achieve the client's preferred goals. We start with the end point, and what our job is to figure out how to get to that end point. On the other hand, we're located within universities, and universities are designed to engage in disinterested scholarly pursuit of truth, wherever it leads. And Barbara was resisting the idea of how do we deal with these two things simultaneously, that we need to pick one or we need to pick the other. Toward the end of that piece, Barbara made a biographical point. Almost all legal academics, she wrote, once made a decision against the academy. We decided to go to law school and become lawyers instead of going to graduate school and becoming professors. At some later time, we reversed that decision and became academics after all. Unlike academics in other fields, almost all of us came late to the decision after having earlier decisively rejected it. Now, to be sure, Barbara has the skills of a first-rate legal scholar. Her tenure piece, Law and the Crystal Ball, Predicting Behavior with Statistical Inference and Individualized Judgment, has everything going for it except for the fact that the stuff after the colon is way too long. It was one of the first articles to address an issue that bedevils us even today: how to deal with algorithmic decision-making on issues like release from prison or pretrial detention, how to deal with algorithmic decision-making for the provision of public benefits, or for things like the extension of credit. Barbara's insistence there that we decide, as she said, whether accuracy should triumph over all other values, and that to make that decision we have to know what's being allocated, is even more pressing today in the era of big data and artificial intelligence. And her later article on the jurisprudence of race-based peremptory challenges, which was informed by her experience litigating the question in the Brooklyn DA's office that you just heard about, in the ventriloquism of Elizabeth Holtzman, has been widely cited for its innovative reframing of the issue to focus on the interests of excluded jurors and not just on the interests of either the prosecution or the defense. But Barbara's significant contribution to the law actually came from her decision to make yet another reversal and to leave the academy for the courtroom. And that's why everybody else you're hearing about tonight is not going to be talking about Barbara as a professor. But it was in her making and living out that decision to change, to reverse yet again, that Barbara became my model, not only of how to be a lawyer, but it may seem ironic enough, of how to be a law professor as well. As I mentioned a moment ago, my introduction to anti-discrimination law came in the spring of my first year in the sex discrimination class that Barbara co-taught. There we discussed Dothert against Rawlinson, a case that formed the linchpin of my argument earlier this year that Title VII protects individuals from being fired for being gay. We didn't have a textbook in the sex discrimination class because there wasn't yet one. It was the only class I took in law school that had more women in the room than men. The novelist Mary McCarthy once described Yale as a place where, as Mary McCarthy said, it was bad taste to admire anything too wholeheartedly. The idea about Yale was to be cool and diffident. Barbara was decidedly neither. Barbara was brilliant and hard-edged and not at all afraid to show it. She showed us that it was okay for women to argue and to push back. In the fall, I decided to take Barbara's criminal law class. That class was where I came up with the idea for my law journal note, a comparison of the model penal code's states of mind with the requirement for proof of discriminatory purpose under the Equal Protection Clause. And I'd always assumed that Barbara would be there to supervise my writing of the note and the like, but towards the end of the semester, she came into class one day and announced she was taking a leave of absence to work in the Brooklyn County DA's office. Barbara was then on the verge of making her final career reversal. She never returned permanently to the academy. Instead, she launched a career as a prosecutor and appellate lawyer for the federal and state governments, and ultimately Solicitor General for New York and acting Attorney General. Barbara's decision had two huge effects on me. The first of them was that a few months later, Barbara invited me to spend part of the summer with her at the Brooklyn DA's office. It was a great place to work. I got to write my own briefs, but I also got to work on a huge investigation. While my friends who were at big law firms got to take cruises around Manhattan and go to fancy dinners and the like, we were taken to watch autopsies at the King County Medical Examiner's office, and then to visit Rikers Island, where I got to go to the special wing for 16 to 20-year-old violent pretrial offenders who were cross-dressers. Only in a state as large as New York could you have an entire wing devoted to that population. The case I remember best, though, is not one of the famous cases. It's one instead in which the office confessed error on a violent felony offender sentence. And as you know, in New York, if you've been convicted of several violent felonies, you get an enhanced sentence for the next one. This guy had a really bad lawyer representing him, lawyers who were known as pelicans at the time, because the appellate division appointed these people. And there's a famous article entitled, "I Want a Real Lawyer, Not a Pelican." But in any event, this guy's lawyer had not figured out that the effective date for the new enhancement provision was actually after the date this guy had committed the crime. And I noticed this, and I went to see Barbara about it. And Barbara said, well, we have to confess error here, even though the lawyer had not noticed it. And we had to go downstairs to Liz Holtzman's office to describe the case and get her approval to confess error. What impressed me most about this was that Barbara never questioned that it was our obligation to protect the defendant's interests. She was the embodiment of the precept that the government wins whenever justice is done its citizens in the courts. She was to make that same point later, as you've already heard, when she urged the United States Supreme Court to decide that the Constitution forbids race-based peremptory challenges, even though many prosecutors believed that those were to their advantage. The second effect that Barbara's change had on me is one I didn't put into words until last year, nearly 40 years after that magical summer. The Stanford provost asked a bunch of us who were sitting around a table to describe a faculty member who had had a profound impact on our lives. One colleague named a Nobel Prize-winning economist. Another named the first professor who showed him that mathematics could be beautiful. I named Barbara, not because of what she taught me in sex discrimination, although I still use those lessons to this day, or in criminal law. And not even because she was the first and most exacting editor I ever had on a brief, but because she taught me, by leaving Yale to go to the Brooklyn DA's office, that status is less important than the work that one does, and that being at a fancy law school was not the only or even the best way to have your career, and that when you're not fully happy with your job, you can't do your best work. Barbara went into the state system before blue state federalism was a thing. She went to Brooklyn before it was a place to be. She showed me that wanting to practice law as well as teach it is something that very smart people do. She gave me the courage to follow my own commitment to work at the NAACP Legal Defense Fund and then to remain a civil rights lawyer as well as a scholar. She also taught me to be generous to young people and to pay that forward. In The Rebel Angels, the great Canadian novelist Robertson Davies has one of his characters quote an alchemist named Paracelsus, who says, "Be not another if thou canst be thyself." What makes Barbara Underwood such a great lawyer, as well as such a great model, friend, and mentor, is how fully she has lived out that commitment. She is herself, which should inspire us all to be our best selves as well. Thank you.
Keeps getting better. I'm a Canadian and we're quoting Robertson Davies. Fantastic. I'm thrilled now to introduce Janet Sable, who serves as Attorney-in-Chief and Chief Executive Officer of the Legal Aid Society. She spent a quarter century with Legal Aid before joining the New York State Attorney General's office, where she served as Executive Deputy Attorney General for Social Justice, and finally Chief Deputy Attorney General before then returning to Legal Aid. Like Zach, Janet is a graduate of the law school where she was a Root Tilden Scholar. We are tremendously proud of her and grateful for her to be here tonight. Janet.
Well, I too am very honored to be here to get to speak on behalf of Barbara. I consider myself one of Barbara's first legal aid friends, and I know that the Attorney General's office now has a lot of people who came from my background, but Barbara and I forged a very interesting friendship because I was all of a sudden in a world of prosecutors at the Attorney General's office. But let me just, we all know how brilliant Barbara is, and really that goes without saying. And we know that she is just extraordinarily accomplished. But I was trying to think of what it is that makes Barbara, Barbara. And I kind of came up with this idea that Barbara is both fearless, extremely fearless, and totally grounded. And that informs just so much of what she does and how she engages with all of us. She's fearless in the confidence that with the help of others or the input with others, she can become smart enough about pretty much anything. She's fearless in her willingness to look for solutions where none are obvious or even clear, or where it means going against the grain. And she's grounded in her commitment to cultivate her team, to mentor, to work with communities, and to work for justice. But she's also really grounded in feeling that the work isn't done until she's found the fair and just resolution, whether it's the role that the prosecutor might have played or whether it's a completely different outcome. Barbara is looking for fairness and justice. So my job today is to introduce you a little bit to Barbara's time at the New York State Attorney General's office. Barbara and I overlapped at the Attorney General's office between 2010 and 2018, where, as you heard, I was part of the executive team there, and Barbara was the Solicitor General. She began her stint at the Attorney General's office in 2007 as Solicitor General to then Attorney General Andrew Cuomo. She was so skilled at the job that it was virtually a foregone conclusion that when the administration changed, Barbara would remain in the role. Now, I know there's a backstory there, but still. And she thrived in the role of Solicitor General until May 8th, 2018, when, on a few hours' notice and with a whole lot of upheaval, Barbara became the first woman to serve as New York State's Attorney General. Barbara's fearlessness was never more evident than that Monday evening when Brian Mahana, Chief of Staff at the AG's office, had the honor of asking Barbara in a bar in the neighborhood, was she ready to assume the position of Attorney General the very next day? And Barbara said, okay. No hesitation, no fear. There was a job to be done. There was an office to represent. There was a role that Barbara had to play. And indeed, she was ready not only to serve as New York's premier legal and analytical thinker, but also to lead the sprawling statewide office of the Attorney General, as New York's chief law enforcement officer. And lead she did. Barbara's poise under pressure, combined with the extraordinary respect and admiration that she had for all the staff and they had for her, enabled the office to flourish and do better work than we had done before. Much changed under the AG's office with Barbara at the helm. Barbara led us to envision an Attorney General's office without a politician as principal. With the utmost respect and admiration for the many former and the current Attorney General who navigate their political and chief law enforcement roles seamlessly, Barbara recognized that her 8 months as AG until the next statewide election created a truly unique opportunity to serve the people of the state of New York with no political ambition. And with not, by the way, having to spend her after-hours time making phone calls to raise money for the next political campaign. The antithesis of a politician, Barbara embraced this opportunity, and as someone has already said, she was determined not to be a caretaker. The idea of Barbara being a caretaker is just impossible to imagine. For those of us in the office, it was a magical time. And not just because Barbara broke the office's glass ceiling, for which we were so grateful and New Yorkers were so grateful. As Solicitor General, Barbara had been involved in aspects of many of the investigations that had been pending in the office. As Attorney General, she asked the executive team to rethink those same investigations de novo, to reconsider the evidence, the goals, the outcomes we were working towards, and to test our underlying assumptions. Only then did Barbara give us the green light to proceed. And the office achieved major accomplishments during Barbara's limited tenure as Attorney General. There was the Charter Communications record-setting $174 million settlement of allegations that it knowingly defrauded customers. There was the court order directing the Environmental Protection Agency to comply with the Clean Air Act's requirements to address pollution from upwind states. There were civil settlements with hospitals that were unlawfully billing rape victims for forensic evidence kits. There was a groundbreaking $330 million False Claim Act settlement with Sprint to recover unpaid sales tax. And, of course, there was the dissolution of the Donald J. Trump Foundation amid allegations that the Trumps had used the foundation for personal and political gain or benefit. Add to this was New York's leadership under Barbara in more than a dozen collaborative efforts, probably it was 24, I really lost count, although I'm sure Barbara will know, of efforts to fight federal actions, and whether that ranged from defunding Planned Parenthood to the federal efforts to undermine the Affordable Care Act in so many different ways, and to rescind the protections available to immigrants, including to Dreamers. But Barbara had been tapped to become the New York State Attorney General because of her hugely successful run as Solicitor General. And we are so glad that she continues in that position today. As Solicitor General, Barbara did and does still solve the thorniest of legal problems, provide the voice of legal authority and good judgment, and is the person, at least while I was there, who was called upon to move an adversary, or even from time to time an intransigent state agency to come around to a position that was the right outcome. As Solicitor General, Barbara argued well over 24 cases in the New York Court of Appeals, where she is a court favorite. They will say that openly. But also in the U.S. Court of Appeals for the Second Circuit, and as well as arguing in the Supreme Court. You've already heard reference to the fact that just this last term, Barbara argued the Department of Commerce versus New York, winning a critical 5-4 ruling striking down the administration's plan to add a question requiring census respondents to declare their citizenship status. It was a major victory. Barbara is not only a sophisticated thinker, an amazing public servant, but she is a people person. Barbara has built an astonishing team in the SG's office, the envy, frankly, of attorneys general across the country. While demanding a lot of her staff, she takes enormous pride in fostering that community, in developing their talent, and promoting new leadership among them, and helping them to propel in their career, as Pam Carlin has already indicated. So both as Attorney General and as Solicitor General, Barbara embodies the highest standards of the legal profession, promotes the advancement of justice, is a wonderful collaborator and mentor, is a fearless trailblazer for women in the law, and to those of us who had the pleasure of working with her every single day, is a terrific colleague and friend. So maybe I should say Dainu, but in any event, we are thankful for all that Barbara has done for all of us and everyone in New York. So thanks.
Thank you, Janet. And finally, it's a real pleasure to introduce Seth Waxman. Seth is a partner at WilmerHale, where he is one of, I would say, the leading Supreme Court advocate in private practice today. He has had a tremendously distinguished career, including serving as Solicitor General of the United States from 1997 to 2001, during which time General Underwood was his principal deputy. It's a real pleasure to welcome Seth here to NYU.
Thank you, Dean. And I want to thank the Journal for welcoming me to come give this talk. It's really a personal privilege to speak today at a law school that I have admired so heartily for so long, and at a university that I have long been very proud to represent. And it is nothing short of an unalloyed delight to be able to offer remarks today about a woman that I've admired for so many, many years. I don't know why Zach Carter has been given the opportunity so many times in the past to extol Barbara and I haven't, but I aim to rectify that difference. Barbara Underwood entered my life in January of 1975 when I stepped into her first-year class on criminal law. And yes, you are going to hear another speaker talk about Barbara Underwood as a professor. Pretty much everything about law school interested me, but Professor Underwood's class really stood out, and not just because the subject of what conduct a society chooses to criminalize and why and with what severity is so intrinsically interesting, but really because of the professor. On a faculty that, at least at the time, counted many, many truly excellent teachers and brilliant minds, Barbara Underwood stood out. She was not a performance artist. She was not delivering polished lectures. Certainly, the purity of her intellect was apparent to everybody, But what was remarkable was the way that Professor Underwood, in her quiet pedagogy, made us students feel as if she too was learning many of the things that she was teaching us. Of course, that was not the case. Barbara had complete mastery of the subject. But in her unassuming way, she managed to conjure the exciting illusion that our own professor was discovering the same insights that she was in fact imparting. And so the following year, I eagerly enrolled in Professor Underwood's advanced criminal law course, and it was equally engaging. And I started looking for articles that she had written, and I didn't find many, or any. And that really puzzled me. And so when I became managing editor of the Law Journal, I went to Barbara's office and I asked whether, on behalf of the journal, she would consider publishing an article with us. And in a response that I know that any of you who know Barbara will recognize, she said, "That would be lovely." But she then explained that the piece that she was working on wasn't quite ready. So I asked if I could see it, and she gave me a copy. The draft, which addressed burdens of persuasion in criminal cases, was wonderful. It was original, it was clear, it was interesting, and it was on a topic that was plainly of significance. So I suppose with taking some unwarranted license, I shared it with our articles editors, Robert Post, who was my law school roommate and became dean of the law school, and Alex Alenikoff, who went on not only to become a distinguished professor, but the head of the INS, the general counsel of the INS, and our editor-in-chief. And everybody read it, and we had a meeting. And no one in that meeting could think of any way to improve it. So I made another appointment to see Professor Underwood, and I told her that I had read the article, and I acknowledged that I had shared it with other officers of the Yale Law Journal, and that we had accepted it for publication. To this day, I can't characterize Barbara's reaction to that when I told her that we would like to publish it, but publish it we did. And promptly, other articles written by Barbara, equally original and important, followed in its wake. And Barbara Underwood made her distinctive, indelible mark in the world of legal scholarship. But as you've heard, while that was enough to earn her tenure at Yale, it wasn't enough to hold her in the academy. From my new home, then new home in Washington, D.C., I followed Barbara's career progression with interest and admiration. Like her scholarship, it was original. And many years later, to my delight, our paths crossed again when I went to work for the Deputy Attorney General, and Barbara was serving as the first assistant in the United States Attorney's Office for the Eastern District of New York. When I became Solicitor General, my most urgent responsibility was to fill my previous job as the principal Deputy Solicitor General, also referred to as the political deputy because it is the only other non-career position in the Solicitor General's office. Now, as you might imagine, many, many, many qualified people applied. Barbara Underwood was not among them. Just like so many, many years ago, she had not been one of the many, many, many law professors who had submitted articles to the Yale Law Journal. But a mutual friend of ours told me that she thought that Barbara might be interested in this position. So I called her. I believe I reached Barbara at her sister's house in California, and I said, I've heard that you might be interested possibly in considering becoming the principal Deputy Solicitor General of the United States. And Barbara said, As a matter of fact, I would be. Now, if I was a better person, I would have restrained myself from saying, as I did, you certainly have found an unusual way to communicate that interest. But Barbara said, yes, she was interested enough at least to come to Washington and sit down and talk about it. Now, the prospect of bringing Barbara into this position held challenges for both of us. For my part, filling a political position, a very, very significant political position with a career prosecutor was totally unprecedented. And it raised eyebrows in the Justice Department and in the White House. For Barbara's part, undertaking this new, very considerable and very consuming responsibility in Washington while raising a family in Brooklyn, and here I am referring to both other members of her family, not just Rob, but also Marty, presented a really novel challenge. But I think we each took a deep breath, and we each jumped, and what ensued was wonderful. Barbara and I worked together as a team for over 3 years, during which we shared professional responsibilities and personal joys and challenges. And Barbara approached her work in the Solicitor General's office in much the same way that she had conducted herself as a professor. Her writing was beautiful. Her oral argument style was reminiscent of her teaching technique. When she was asked a question by the justices, even though it was the very same question that she had been asked at a moot court, Barbara would pause, which is a reckless strategy in a Supreme Court in which any moment of silence prompts another question, and leave the justices somehow in a sense of tenterhooks as to what she was going to say or whether she was going to say something. But the effect of it was that when Barbara explained something, it just seemed original. It didn't seem like it was a practiced answer that she had anticipated and had a glib response to. And Barbara's collaborative approach in the office also earned her universal respect. Now, many of you may not know but that the Solicitor General's principal job is to decide hundreds of times each year what legal position the United States should espouse in litigation and in what context. And often, different offices within the executive branch have different views on those questions, sometimes diametrically opposed views, and sometimes very strongly held views. Barbara conducted conferences in these cases in the same spirit in which she conducted her classes. Regardless of the outcome, everyone felt that they had been heard and that Barbara had learned something from hearing from them. When I resigned following George Bush's inauguration, Barbara served as acting Solicitor General, and with great distinction. The Solicitor General's peculiar tradition of independence carries with it the potential for some friction with the White House, and perhaps even with the Attorney General. In the divisive wake of Bush versus Gore, that potential was palpable. But I never heard anybody in the Bush administration ever speak other than glowingly about Barbara's work, her quiet, inclusive manner, and her professionalism. When Barbara was named New York Solicitor General, not one of her many, many former colleagues and admirers in Washington was surprised in the slightest. To borrow a Yiddish expression, it was in our minds beschert. It was a match foreordained by God. Why on earth wouldn't someone with Barbara's talents and experience not become Solicitor General of New York? Now, Up until today, I knew nothing whatsoever about how Barbara came to assume that position. But I was sure that it was nothing other than the following. Someone, not Barbara for sure, told Attorney General Cuomo that Barbara might be interested and that she was wonderful in every respect. And of course she was. Barbara's masterful stewardship of the Solicitor General's office and her selfless service as acting Attorney General of New York at such an unsettled time are, of course, well known to everyone in this audience. You are all the beneficiaries of her excellent judgment, consummate skill, and hard work. And so are we all in this nation, really. Thank you, my dear friend and teacher.
Thank you to all of our speakers and to all of our guests. Now, on behalf of NYU Annual Survey of American Law, we are honored to dedicate our 77th volume to Solicitor General Barbara Underwood. Yes.
First, some thank yous. Thank you to the Annual Survey Board for the great honor of this dedication. Thank you to Dean Morrison. And especially thank you, I don't have thanks enough for the kind words of each of these wonderful speakers. I feel so deeply honored that you've come to participate in this ceremony, some from nearby, but also Seth from Washington and Pam from California. It's overwhelming. It's been so moving to sit here and revisit with you so many important parts of my career and my life. And I'll say that while some factual details were maybe not exactly right, the feeling of it, the spirit of it, the reality of it was just right and amazing. I also want to give special thanks to Judge David Bazelon, who left us more than 25 years ago. He gave me a chance when many judges were openly refusing to hire women law clerks. I learned so much from him about law, about judging, and about making the best use of your one and only life. And he convinced others to give me a chance too. I've just recently heard some stories that I didn't know anything about the role he played in various things that were made available to me later. I hope he would be proud. I want to say just a few words about the work I'm doing right now, about keeping up the fight for equality and justice, and about the special role of state attorneys general in that fight. When political leaders encourage disrespect for courts and for the law, we're all inclined to feel a pang of despair, but especially those of us who are lawyers, who think of the law as a tool for justice, but we can only make it a tool for justice in the courts. And if something is happening to the courts, it makes what we do hard. But it's so important to overcome that feeling of despair. It reminds me of another bleak moment in 1971 when I started work as a clerk for Supreme Court Justice Thurgood Marshall. He had a long career of fighting for equality and justice, both before and after he joined the court, and the law clerks were eager to join him in that work. Just as we came on board, 2 vacancies occurred on the court. Justices Black and Harlan stepped down. President Nixon announced his plan to nominate new justices who would shift the court dramatically to the right. The court was slated to consider many important issues that year, including capital punishment, race and sex discrimination, women's reproductive freedom. The court's likely swing to the right was a terrible blow for Justice Marshall. He told us that he felt his life's work was about to slip away, and nothing could be done about it. And when the law clerks came in to talk with him about possible dissenting opinions, he would turn his back on us. He would actually wheel his chair around and turn his back to us and say, "I'm tired. This is your fight now." One day, his wife, Sissy, came in to talk to the clerks. She told us it was our job to raise Justice Marshall's spirits, to get him to see that his voice was still needed, that it was still worthwhile for him to speak out in dissent. And so we did. I think it made a difference. In any event, I've checked, and just to confirm my memory, the justice did throw himself into dissent that year, and for many years after. In what threatened to be a time of civil rights rollbacks, he said he was laying down a marker for a brighter future. And that's what we're doing in the New York Attorney General's office, too. The office has never been stronger, and our work has never been more important. We are fighting for justice now, when we can get it, and we're also laying down a marker for a brighter future. So when people ask, as they increasingly do, "Do you ever despair?" my answer is no, we don't have time for that. It's more important than ever to keep our energy up, to focus on the future, and to do what we can to help ensure justice and equality for all New Yorkers. And there is a lot we can do. The current crisis at the national level has shown us how important the states are in our federal system of government. There was a time when many of us were deeply skeptical of federalism. States' rights, after all, is another name for it, and states' rights acquired a bad name in the civil rights era when states were resisting the effort of the federal government to desegregate schools and jobs and housing, and saying they had a sovereign right to resist. But recently, states like New York have played an important role in restraining the excesses of the national government. I think we all have reason now to be glad the Constitution reserves some power to the states. The New York AG's office, with a coalition of like-minded AGs, has been hard at work fighting in the courts, filing suits against the Trump administration's assaults on our environment, our workers, our health, our civil rights, and especially the administration's many anti-immigrant policies. I thought about ticking them off, but it would be a very long list at this point. There are critics of this litigation, of course. They say these controversies are political, not legal, and we should stick to the task of law enforcement. But they are wrong. What we are doing in these cases is law enforcement. We're insisting that when an agency announces a new policy, it must follow the laws that Congress has enacted or that the Constitution prescribes. Laws that limit what agencies can do, and laws that require them to follow procedures and give reasons when they act. I feel so honored and so fortunate to be in a position to do this work, to marshal all my skills and experience in the service of the public interest, and to bring together a truly splendid group of lawyers, some of whom are here tonight, to help do that work. And with Attorney General Tish James and her extraordinary leadership team, some of whom are here today, we continue to do this important work at the very highest level, and we're not going to stop. Thank you. thank you all for being here to share this amazing, amazing moment for me. Thank you.
Well, thank you from me as well. We're very grateful that all of you were able to join us here, and we'll have a reception in this room immediately following that I hope you will join us for. If you'll just allow me a moment of personal privilege, it was December 1998 that I first met Barbara Underwood, at the same hour that I met Seth Waxman, because they were both interviewing me as a baby lawyer for a Bristow Fellowship, the junior-most lawyer position that exists in the Solicitor General's office. I remember that interview. I remember thinking I totally bombed the interview, so I can report that some combination of Barbara and Seth are compassionate as well. But throughout the year, well, maybe once. Throughout the year that I was lucky to serve in this very junior capacity, I was fortunate to see really the model of legal excellence and humanity in Deputy Solicitor General Underwood. And so we are thrilled to be able to really bring honor to ourselves by your allowing yourself to be associated with the school and with the annual survey. And to the students in the room, one of the reasons we continue these traditions is to hold up models to which you can aspire, and there is no better model than this one. Thank you.